Deputy Croft informs Ms. Mulligan that she is under arrest for disorderly conduct and menacing. According to Section 525.060 of the Kentucky Revised Statutes, quote, "A person is guilty of disorderly conduct in the second degree when, in a public place, and with intent to cause public inconvenience, annoyance, or alarm, or wantonly creating a risk thereof, he engages in fighting, or in violent, tumultuous, or threatening behavior, makes unreasonable noise, refuses to obey an official order to disperse issued to maintain public safety in dangerous proximity to a fire, hazard, or other emergency, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose." Now, even assuming for the sake of argument that Ms. Mulligan made unreasonable noise, the disorderly conduct statute requires that the individual act with intent to cause public inconvenience. Section 525.010 of the Kentucky Revised Statutes defines public as meaning, quote, "affecting or likely to affect a substantial group of persons." This means, as the Sixth Circuit Court of Appeals, which has jurisdiction over Kentucky, explained in the 2011 case of Kennedy versus City of Villa Hills, that, now quoting, "Kentucky law does not criminalize arguments and noise that disturb only police officers because such conduct does not risk public alarm. Indeed, because the First Amendment requires that police officers tolerate coarse criticism, the Constitution prohibits states from criminalizing conduct that disturbs solely police officers." Similarly, the Sixth Circuit held in the 1997 case of Barrett versus Harrington that, quote, "It is evident that the First Amendment right to criticize public officials is well established and supported by ample case law," and that, now quoting again, "freedom to criticize public officials and expose their wrongdoing is at the core of First Amendment values, even if the conduct is motivated by personal pique or resentment. As such, it is highly unlikely that a court would conclude Deputy Croft had probable cause to arrest Ms. Mulligan for disorderly conduct." Now, as for a menacing charge, Section 508.050 of the Kentucky Revised Statutes states that, quote, "A person is guilty of menacing when he intentionally places another person in reasonable apprehension of imminent physical injury." Now, while it is possible that Deputy Croft was startled by Ms. Mulligan knocking on his window, this conduct almost certainly did not rise to the level of menacing, as there could be no fear of an imminent physical injury given the physical separation between Ms. Mulligan and Deputy Croft. Likewise, any so-called apprehension that Deputy Croft may have experienced could not be reasonable, as knocking on a window is a commonly accepted way of getting a park driver's attention and is not a threat of violence.